Good afternoon, everyone. Thank you for joining us today. We have a great presentation for you all on navigating jury selection in a construction case. My name is Jason Rodgers-da Cruz. I'm a shareholder at Siegfried Rivera. I'm also on Division I Steering Committee for the American Bar Association's Forum on Construction Law. I will be co-moderating this presentation with my good friend and colleague, Joe Imperiale. And I'll allow Joe to introduce himself.
Good afternoon, everyone. I'm a partner in the construction group at Troutman Pepper. I too serve on the D1 steering committee.
So before we get started, we have a plug. Joe, why don't we tell everyone about the construction trial desk book that's out?
Sure. The inspiration for this program is the construction trial desk book. You can purchase it through the ABA's website. It was published and written by many members of the forum, including many who reside at Division I. So
yeah, and we invite everyone to join the American Bar Association. You know, obviously, members get a discount. And of course, if you're a part of a section, such as Joe and I were part of Division I, you'll get a discount on that as well. The best chapter, though, which Joe and I believe, I mean, look, all the chapters are great, no question about it, but the best chapter is chapter 9, jury instructions and verdict forms. Joe and I worked on this for a long time. We're proud of our work, and please read, please pick up the book and read this chapter. Of course, that's a joke. All the chapters are great. It's a great book altogether. So, introduction of our panelists and speakers today.
sure, I'll start with Galina Davidoff. Galina is a trial consultant with a Ph.D. in psychology. If I'm trying a complex case, there are a few things I am sure I bring to trial, and Galina is certainly one of them. Her services range from mock trials to jury selection, to identifying winning themes, witness prep, and more. Galina, say hi.
Thank you. Hi, thank you, Joe. Always a pleasure to work with you.
You as well.
So Oliver Morales is a good friend of mine. He is an assistant public defender at the Miami-Dade Public Defender's Office, which is one of the largest public defender's offices in the United States. He's been there for 30 plus years. He's held numerous supervisory positions in training young lawyers and lawyers at the office and actually throughout the state. He has selected more juries and tried more cases than anyone that I know. Thank you, Oliver, for being here. Say hi to everyone.
Hello, everyone.
And of course, we have Stuart Sobel. For those of you in the ABA Construction Forum, he really needs no introduction. He's been very active for many, many years, given a lot of presentations. He's also a shareholder at Siegfried Rivera. He's a fellow of the American College of Construction Lawyers. And when it comes down to trying construction cases, he's actually tried more construction cases than when I know. He actually taught me how to try a construction case and has been a great mentor to me in my construction practice. Say hi, Stuart.
Hello, everybody.
All right, so I'm going to turn it over to the panelists.
Jason, one sec. Before we kick it off to them, I think most of you noticed we have a poll running here. If you could take a sec to fill it out, that would be great. Maybe you all can get started, panelists, on the presentation, and I'll end the poll when it looks like we have enough participants and kind of give the results so we can gauge the relative experience of our audience in terms of jury selection.
And then also with regard to any questions, we're going to be taking some time at the end of the program to answer any questions. But if there's anything that pops up that's relevant, Joe and I will take a look at it and ask the panelists that question. Thanks, everyone.
Good afternoon. Excuse me. Good afternoon, everyone. Oliver Morales here. I guess the very first concept is how the process works. And usually what happens is once you announce ready for trial, you show up on your trial date. And one of the first things that's going to happen is about 30 to 50 people are going to show up in the courtroom, and the judge is going to sit them down in a specific order. And they'll give you a packet usually with the names and certain questions, preliminary questions regarding their qualifications. And then it's time. The judge usually is the one that begins the process, and the judge will usually have a series of rote questions that will ask the panel. They may go through each individual questionnaire that the jurors filled out. And then after he's done with that process, then you get your moment on the spotlight. And it's probably the most difficult aspect of trial work, at least in my estimation. It took me many times to get comfortable with the idea of talking to 30 to 50 strangers, and not only talking to them, but get them to kind of see the world your way, and to navigate a process which most jurors do not feel comfortable talking in public. It is your job to get them to talk to them in public. And that's how the process begins. It's a scary thing for the trial attorney. It's a scary thing for the jurors themselves, and you have to keep that in mind. Some of the things that always you're going to be looking at when you're questioning jurors is their answers, and their answers may have reasons for them to be stricken for cause, whether they have certain beliefs that are not in line with what the law is or what they should be doing, or because for whatever reason you just don't feel that they're on your corner of the ring. An aspect of the striking system is also what's called backstrikes. Now, in the state of Florida, backstrikes are absolutely allowed for everything. I don't know whether in some other states that's something that only the judge can decide upon, or whether backstrikes are not allowed. That's something that we're going to discuss in further detail as we get into the lecture. Also, part of jury selection is to make sure that, depending on the length of the trial, when you're thinking about choosing alternates, when there might be a likelihood of alternates being put on the panel, you have to as seriously consider alternates as you would members of the panel.
So Galina, before you get going there, we have a good number of responses to the poll. So let me end this and share the results so we can see the relative experience of our audience here. About 3/4 of the folks have, or 3/4, three-fourths of the folks have selected a jury before. More than half have selected only once. When it goes to more than 5 times, only 14% have selected more than 5 times. And our experience is predominantly in the civil arena. So against that backdrop, Galina, why don't you go ahead?
Thank you, Joe. I'll close it here. Okay. So as you may notice, the title here says jury deselection, because it's in order to emphasize that when you are picking a jury, you're not actually picking the people you like and putting them in the jury box. What you can actually do is strike jurors you don't like. You either try to strike them for cause, or you use your limited number of peremptory strikes. So as you prepare for this process, you have to be sort of action oriented. You got to prepare to what you can do as opposed to what you want. And when people ask me, so who is our ideal jurors for this case, that usually is a warning sign that this attorney probably does not have a whole lot of experience picking a jury. because if he or she did, they would know that the ideal juror doesn't usually show up, is out on vacation, or the other side can see them right away and he's striking for cause, or a peremptory strike is used on this juror. So that is sort of overarching point that we all agree on, all the panelists, and that's one of the main takeaways for you from this program. And then there is an order how you get to those strikes. And number one thing is identifying what is really important for the jurors, because as you prepare your case for trial and sometimes years of litigation, you struggle with a lot of different issues. Not all of them matter to jurors. Sometimes what matters to jurors is not something you've dealt with in the course of litigation, because they may be concerned about public safety or environmental or other issues that it's not something that is actually part of all the legal motions. So as part of your analysis, whether or not you do any jury research or not, it is good to understand what is important for the jurors. If you cannot do jury research, you talk to people in your office, talk to non-lawyers, what are their first reactions? What is it that they want to know? So once you've done that, the next stage is to identify your themes and your story, because that again is going to influence who is going to relate to the story and who is not going to be able or willing to relate to the story. One of the most memorable jury selection and construction cases done was Joe, and that was a case involving counterclaims and a construction of a pipeline in the mountains, mountainous terrain, and the contractor and the gas company were blaming each other for everything. And when I first got involved, it was a whole list of causes for why the project was delayed. Environmental reasons, poisonous snakes, landowners with guns, all kinds of things. What it came down to, after we talked it all over, we didn't do jury research in that case. Actually, it was just a number of discussions and me studying the case documents. This was a case about a man, I think was his name Tom or Tim, that he left his heart on that mountainside. He had 2 heart attacks. He tried so hard to make it work. It literally broke his heart. And our theme was about trying, not about being perfect, not about the contract language, not about the snakes and the guns, but about the honest to God attempt to get it done. And that subsequently influenced the kind of people we didn't want on the jury, which would be the kind of people who wouldn't be moved by that all that much. And then having done that, you formulate your juror profile, you list the characteristics of people that you care about. That would be, as most construction cases, any experience with construction, experience with renovations, experiences with public construction projects. And I think I've got a little bit more about that on the next slides. And then after that, you list your voir dire topics. So your list of things that are important probably going to be about 5 to 10 kind of general topic, litigation experience. It may be employment experience because somebody has gotten fired. There could be issues related to race and gender, and large versus small, people's attitudes to large corporations, and those kinds of things. So you list your topics, and then if we can move to the next slide, You decide how you want those questions asked. Obviously, if you're in the federal court, all you can do is submit your, talk to the other side, submit the questions to the judge and have the judge ask the questions. Not an ideal situation because the judges try to make things move fast. And when you end each question with a statement, and would it make you unable to be fair and unbiased, then you don't get many informative responses. So one of the issues for you to decide, do you want a supplemental juror questionnaire? And while in some sense, like we always want more information rather than less, but it pays to think about it carefully. For example, if you really don't have the staff to analyze the questionnaire, while the other side does, then you will be disadvantaged because they will get out more information out of that questionnaire than you will be able to do. Then you will be swamped with the information that you can't really process. So you need your team if you want the questionnaire. It's not something that the trial lawyer could hope to do alone. So you want a questionnaire if there are numerous issues. You definitely want a questionnaire if it's some kind of publicly known projects where people may have opinions, and then you may hear really hostile opinions. Say it's a public transit project or a project that created traffic delays, anything of that sort. So you want to be careful there. Another issue, if your supporters are easily identifiable, for example, you represent a large company, and the other side is a small, mom and pop operation. So the other side will know that they need to strike more pro-corporate types from the jury, and they're pretty easily identifiable. So that is an easy job for them, but you need to figure out of all the group of people who generally would be more sympathetic to an individual, which ones of them would be more strongly against you. So those are the things to think about. And then you get to formulating your voir dire questions. And you want to ask questions that zero in on your adversaries and avoid questions that highlight your supporters, therefore helping the other side to strike them. For example, if you represent a foreign entity and you've learned in your research, or you think that people who travel abroad would be more open-minded to your story, and people who have passports will more likely to support you, well, don't ask about that. If in the venue where you're in, only a minority of people had done that, because if you ask that, you highlight them for the other side. So you try, if you represent a contractor, a builder, ask people, have you had any bad experiences with construction? Don't ask them, have you had any wonderful experiences with construction companies where the work was done on time and on budget? Please tell me about it. Can we go to the next slide? And I think here, Oliver is going to talk about the other aspect of it. I just want to say, I think I'll save it for later. Oliver, take it away.
I mean, one of the things that I think is important in jury selection is that you're there to educate the jury on concepts which they typically they don't deal with on a regular basis. And so therefore you have to become a teacher, and a teacher, inherently has to educate and has to entertain in order to get the education through. You can't be dry, you can't be pedantic, you have to be entertaining, but with bearing in mind that at all times you're educating the jury about some things that they may never have dealt with before and are never going to deal with again. But because the thing is, if you don't educate them, some of those jurors that you may not want are going to be there. And if you didn't take the time to educate them about the concepts that you want to get across during your trial, they're not going to have an idea, or they're not going to be receptive to what you're trying to deliver. And I guess in construction cases, just like in any scientific case or in a criminal case where there's DNA or not, you have to educate them as to these concepts that are easily, you understand them, but now you have to educate them as to what those concepts are about. And you have to do it in a manner that's simple and that's understandable to all levels of education. Because in my experience, when you get a panel, you're going to get professionals, you're going to get mid-level educated individuals, and you're going to get people basically that have not gone no further in their schooling than a high school diploma. It doesn't mean that they're dumb, but it does mean that they haven't been educated in the language that's used and some of the concepts that are going to occur in your litigation, engineering concepts, accounting concepts, all those things. And in addition to that, you're going to get individuals that are not used to dealing with numbers in the millions. I mean, most people that you would run into in the real world consider $1 million to be a lot, but I'm sure some of these litigations, we're talking about tens, 20s, if not more in the millions. And you have to get people accustomed that in the business world that you're representing, these aren't unusual numbers. Suing a company for $20 million is not an unusual number. So you have to kind of get them used to the idea that these numbers are fair and reasonable, and it's not just a greedy lawyer trying to get more than what they deserve.
What construction trials have in common with all trials is that the jury is called together to decide disputed issues of fact and the impact of those facts on the law as the court instructs them. So the construction case is just another context for resolving a dispute that arises out of human interactions. You may be representing a corporation, but there's human beings who one side may be trying to take advantage of the other side, and you may be tasked with preventing that from happening. So in order for a juror to be able to understand why your cause is just, you have to give them a framework within which to receive facts that that might be foreign to them. As Oliver is saying, you could have a complex trial over the engineering that underlies the construction of a railroad station, for example. But the engineering concepts are only important insofar as getting the jury to understand who is trying to take advantage of a situation. So you have to create a fundamental understanding, and it doesn't necessarily limit to a college educated or a high school educated person. I've had experience trying common law unfair competition cases to rural jurors, and they are hungry to be taught. They're hungry to be taught. It's your role. 46 years ago, my mentor taught me that when you walk into a courtroom to start a jury trial, there is this huge vacuum. The jury has no idea what's going to go on. So when you walk in, you should strive to fill that vacuum. You lead this jury. From the very beginning, you take this jury and you explain the process, you teach them what they need to know, and you do it in a way that will make them understand your cause. Now, in understanding your cause, in selecting or deselecting, as Galina correctly points out, you have to understand, what are you looking, what is your goal? Is your goal to select a fair juror? You remember the joke about the lawyer who gets a ruling in the mail and he calls his client and he says, I got the ruling, justice prevailed. And his client says, appeal immediately. You may not want a fair juror. You may not want an impartial juror. Do you want somebody that's open-minded, persuadable, or like-minded? And how do you figure out which of those you're getting? underlying all of that is the goal of jury selection to try to, and the development of your theme throughout the case, to try to make it important to the juror for the juror's own reasons without violating the golden rule. Why is it important? Why is your view of the case important to the juror personally? Why should she protect her own interests as she perceives them? And think of a products liability case. You know, a baby play jumper that's defective. A juror may say, oh my goodness, I have to award enough damages so that my baby is never put in an unsafe plaything. Now, you can't violate the golden rule, but you can certainly present the facts, whether they're engineering or product liability or a car crash. The car is unsafe, the brakes would tend to fail, in a way where the jurors will understand this is not only important to the lawyers and the litigants, this is important to society. And I'm part of society. I think we can go to the
And
next
I just
slide.
want to, if I can add something, you have to be able to tell the story, like if you're at a bar and the guy goes, what's this case about? And you should be able to, in a few sentences, tell them what this case is about. And once you can do that, then you can develop an entire voir dire predicated on that. Because jurors are hungry for a story. People are hungry for a story. And if you tell them, this case is about this, then from there, you can expand upon and have a meaningful voir dire in order to get people that are going to be aligned with what you're trying to get.
And most typically, the court, before you actually get to question the jurors or the veneer, will read a joint statement that you and your adversaries have agreed upon to the jury. That statement has to be very well thought out. That's the first thing the jury is going to hear, not even the jury, the entire veneer is going to hear about the case before you start selecting the jury. So put some thought and effort into that. That's part of filling that vacuum. Next slide, Jason.
And I absolutely agree with everything that has been said just now. But what is the most important purpose of voir dire is for you to develop intelligence on the jurors. It is for you to learn about the jurors. And you need to develop, but you do, as you do it, you need to educate. And that is why the last point is so important. You've got to practice. If you haven't done it for a while, this is not a simple thing to do. Striking the right tone, making people talk to you, making those questions sound like you were, I don't know, sitting at a bar, or at least not being stilted and scary, because I've seen very good lawyers muck it up because they haven't prepared and the questions sound scary and they don't get the answers. In addition, as you're finishing your preparations, these days, it is important to do some basic searches on the jurors of public information. You don't need to hack into anything, but there is a lot of information out there, especially if a project is well known in the area. And liens and bankruptcies and permits and home ownership, they all are usually part of your juror profile, and they help. And it's better to get somebody who has experience doing that. You can't just hope that your secretary will handle the job.
If I may, one of the things that I think everyone should be doing is have an intern, a clerk, someone in the back of the courtroom, and you hand them a copy of the jurors, the prospective jurors, with their names, and they usually have their age. And immediately they should be doing a Facebook search, whatever, in order to, at least at the bare minimum, maybe you're looking for a more liberal type of jurors. You do a Facebook search on these jurors, and you can say, okay, well, he's a conservative, all his postings are aligned to a conservative kind of worldview. And maybe that's not what you need. You need someone who maybe is a progressive, because because of the situation that's going on in your case. So you kind of have to think about what would be a juror that you may want, and then somewhere in the middle, you're going to get that juror, but having this research being done as voir dire is being conducted by a clerk, so that at the end of voir dire, when you go back with your trial partners and your clients, and you're going over whether you want this juror or that juror, the clerk can hand you the information and say, okay, that guy, although he may have sounded great, look at all his postings. So I think in today's age, it would be a detriment if you weren't, at the bare minimum, have a clerk somewhere in the back of the courtroom doing a Facebook search on these prospective jurors.
It's a modern take. When I started trying cases, you would always ask the potential jurors, you have a bumper sticker on your car. Well, what's it say? Because what they put on their car is generally pretty revealing of their political leanings, of their priorities in life. You can't do that anymore, but you have a better tool, and that's the social media.
Right. I mean, one of the questions we used to ask, it was like, what magazines do you subscribe to?
Yeah.
Yeah, I'm at the Enterprise Institute, the National Review, the Weekly Standard. Okay, we know where you're going. So it's that what Stu said. It's the modern day questions that we don't need to ask anymore, because it's out there for us to look at.
And you'd be surprised how often politics comes into it. Some years ago, I've written an article called "All Real Estate is Political," because a lot of the time, all those questions of funding, the permits, and now the political orientation becomes very relevant to juror profile and is readily gleaned from people's social media.
Right.
And
I'm sorry. And on number 8, what I do is I grab a manila folder, I make a grid, something similar to this, and I put the juror's name and maybe some of the pertinent information that I can get from their questionnaire. And the person doing the voir dire needs to have one, and co-counsel needs to have one, and anyone that's going to have any input on jury selection at the end of voir dire, so that you can then compare your notes. And I think Stuart and I both are of the, we practice the plus, minus, and 0, where if it's a juror that we like, he's a plus. If a juror we don't like, he's a minus. If we're not quite sure or he's kind of neutral, we put a 0. And then this is how, a practical way at the end of voir dire, when you're sitting back in, I guess if they have a conference room in the courthouse or in the corner somewhere, all these, yourself that you questioned them, your trial partners, which are the ones that should be taking the notes. I'm of the mind that when you're questioning, really, you should not be taking notes. You should be making eye contact. You should be continually engaged in the jury selection. And it's your trial partners or your clerks that are taking furiously anything that is said that may come into play when it comes to selecting them or not.
Right. So now go ahead, Galina.
Sorry, I just wanted to say, as someone who's done it more times than I can remember, post-its. Because if some of those jurors are then excused and you need to put a new person in there, small post-its and a pen with a fine point are essential. So that way you don't have to grab a new fold or scratch anything out. You use those. And one other thing I wanted to say, there are those new apps that help you do a jury selection. You got to, keep checking to see if anything good comes out. But the problem is entering information takes more time than making quick scratches on paper. So that is a very old fashioned, but it works. Sorry, Stuart.
A couple of points about this template. This template has to be tailored to the courtroom. So some jury boxes will have 14 seats because they'll have enough for alternates, or they'll have a capital jury. So there's 12 for the capital jury and a couple of alternates. Some will have 15 seats or 16 seats. But the clerk will typically bring down, even for these civil trials, 30, 35, or 40 jurors to question at a shot. Make sure that the sheet that your scorecard, as I call it, is tailored so that you can correlate the box that has the juror's name with his seat. So for example, you'll see juror name, that's row 1, left side. Now, row 1 is the back row for me, not the front row for me, because it's as I look at it. Another point is I try to write the juror's name in as quickly as I can, because I always try to refer to the jurors by their names. Mrs. Jones, Mr. Smith, tell me about your education. You need to make it personal, because very often the jury is going to want to rule for the side it likes. So you want to be genuine. It can't be disingenuous. But now, as Oliver says, I don't have time when I'm questioning a juror and I'm trying to make eye contact and read what they're not saying. All I will put down are pluses, minuses, or zeros in response to questions, or as Oliver will talk about in a minute, if you get the panel talking to each other, and then correlate those with my partner or my law clerk or my paralegal who's working on the same sheet, and we'll compare her pluses to my pluses, and she might have a scribbly that jogs my memory. Why did I write a plus here? Why did I write a minus? Because it's not just, well, there's more pluses than minuses, so they're okay. Those pluses and minuses are weighted, and the weighting comes from your team.
And I use grades from A to D. A grade for A to F. A grade to us, C kind of neutral in the middle, and F will means we've got to get rid of this juror.
Okay.
So juror profile, I spoke a bit about it later. I want to emphasize that the visible demographics could be very deceiving. You really need people's experiences and opinions, most importantly, their opinions. They are the most predictive of people's verdicts. And the demographic just leads you to stereotypes, which gonna hurt your position. And this just lists different issues that come into play. The last point talks about the types of work that juror him or herself is doing, and that colors the way they view a construction case. So professions which require precisions, where deadlines are met, or where there is very little uncertainty, they have little tolerance or understanding of how those live construction projects evolve, unless they had experiences that taught them that. So this is something to pay attention to. And of course, whether they're business owners or self-employed, that often sets people aside.
Now, you
And
can get
the other
that
thing-
information, but what you do with it is Galina's bailiwick. That's why you need Galina sitting next to you. Okay, you're a business owner. Now what? What do I do with that information? That's what your jury consultant can help you with.
Help you before, figure out what questions you want to ask, sometimes during, by suggesting some follow-up questions, and toward the end in helping you decide who do we really want to strike. Thank you, Stuart. So one issue, of course, is whether your surety is involved. And as most of you, I'm sure, know, jurors constantly confuse surety with insurance. And you need to respect that, and you need to address that, and you're going to
encourage it. Sorry.
And you may want to encourage it. It depends which side you're on. But in voir dire, this is certainly something you need to explore. And people who had bad experiences with medical insurance company might be bad jurors for you just because of that. This is very important. And even after you educated them, and I listened to surrogate jurors deliberate, or actual jurors tell me about their experiences on the jury, it's still insurance company image is still very much there. Now, psychological profile is actually very important, and it's pretty simple. One thing that is often forgotten is the leadership potential. How influential will this juror that you're considering be on the jury? Will other people listen to him or her? And that depends on several things. One, their own leadership experience, and it does not have to be professional experience. It could be PTA, it could be church organization, it could be some homemaker that is really charismatic and engaging. And the other aspect of it is specific knowledge about things that the case is concerned. So people who have been in construction, surety, insurance business, anything related to your case, they are elevated to status of a leader, and you need to take it into account. The people you want to strike are people who are adverse to you and have high leadership potential. And you don't want to waste your strike on somebody with a very low leadership potential, because nobody is going to listen to them. So you've got an extra strike, by all means use it, but we've got to think about it carefully. The other psychological aspect is what psychologists call the locus of control. They could be external or could be internal. External is a tendency to blame others and the circumstances for things that happen to you. And so those people readily identify with anybody who claims to be a victim, with people who go first in the case. In the construction cases, people suing each other, but sometimes you can see there is a plaintiff and there is a defendant. So they're most identified with the plaintiff most strongly. Internal locus of control, people who tend to assume responsibility, whether or not they actually belongs to them. Like those are the kind of people who blame themselves, even though it's clearly somebody else's fault. Those people are great for defense. And that is something to think about. And you can find it out if you have a chance to ask open-ended questions. Such, for example, you're talking about a construction, the renovation that went badly in their house. You tell them, like, tell me more about it. Why did it happen? What lessons did you take away from that experience? And if they talk about, like, I should have done more, I should have checked, I should have insisted, that is an internal locus of control. If they talk about all those other bad people and circumstances that made the bad thing happen, this is external locus of control. The last point here is on sort of life satisfaction and happiness. Unhappy people do award more money. They are more likely to sympathize with the victim, and they see a chance to do something. And there you go. I mean, in that case with Joe, the group of jurors we selected, I looked at them afterwards and I thought, oh my God, what a sorry looking bunch of people. They did not look happy at all. And guess what? They gave Joe everything he asked for.
They couldn't get out of jury duty.
They only had to sit for a month, Stu.
This conducting voir dire, this is something that goes along with what Oliver and Stuart were talking about, and what I was saying about practice. You gotta talk to jurors with respect. Don't talk about your case like, I gotta dumb it down for those dumb people. No, you gotta find in yourself the real respect for people who are giving up their time and personal life to be jurors on your case. And out of that respect, you should be as clear and concise as you can. Of course, there's certain themes and topics you have to repeat, but that's a different issue. It also takes courage, because you've got to hear bad things when they're out there. To the extent you can, you'd like to ask for individual voir dire, a juror questionnaire. But one of the most memorable experiences, was skillful voir dire I've heard, was from a plaintiff lawyer who was asking for a lot of money for an individual who by a lot of people would be considered personally responsible for his behavior. And he got all the people just everybody who had this opinion, he invited it, he welcomed it, he showed the respect that of course we all have personal responsibility. And of course, getting a windfall for something that you should have known better, blah, blah, blah. All our jurors, I was on the other side, were gone. They were eating it up, and it sounded unpleasant to his client, I'm sure, but he was extremely successful in getting rid of his jurors. So this is something you can learn how to do. Open-ended questions and follow-up questions, very important, because you want to hear people in their own words, not yes or no answers. Yes or no answers tell you very little and certainly don't tell you much about their psychological profile. And as part of the education, if you know you have a juror who is friendly to you and who is going to be gone, have them talk about the things you want other jurors to hear. But if you have a friendly juror you have a hope of keeping, well, you kind of avoid them and you ask the majority of your questions of jurors who are adverse to you, so you can develop strikes for cause.
Now, one of the most important things that I think is important when you are picking a jury is to be a little bit self-deprecating and humble. And the reason I say this is because, number one, lawyers tend to have a bad reputation. Most people don't like lawyers. And number two, they have a reputation as being kind of pompous and self-important. So if you approach it from the perspective of humility and self-deprecation, throwing in a joke that is on you, I think that goes a long way to get the jury to start being on your side. But you can't do it. You can't do it by copying someone else. You have to be yourself, and that means that you have to practice. And you can practice in front of the mirror. You know, you can be self-deprecating on your own terms. You can be humble on your own terms. But at the end of the day, you have to be yourself. But you don't have to be yourself plus lawyer self, is what I'm trying to say.
You have to be genuine. You have to be genuine. You are there asking these folks who have interrupted their daily lives to help you and your client achieve justice. And that's what you've got to convey. This is not a matter of, you know, me being a big man and I want to put a notch in my belt, another jury verdict. This is, we are here to make the system work, and it only works if you can help us.
Right.
Sorry, Oliver.
No. That's exactly what you need to do. Remember, you're there on behalf of an individual or a company. You're not there on behalf of yourself getting an ego trip by being in trial. Trial is just a means to an end to assist an individual who is in need. So just always keep that in mind, that yes, you are going to be the head honcho of the show, but ultimately it's not your show. It's for the benefit of the client. Now, like I said before, in order to have a successful voir dire, you both have to be an entertainer and an educator. Now, people have dragged themselves in from their regular routine to come in there, and they don't want to hear dry, pedantic legal terms. You kind of have to make it entertaining for them, because that's what they're looking for. An entertained, engaged juror is one that is paying attention. And if you're the one that's doing the entertaining, if you're the one that's doing the educating, they're paying attention to you and to what's important to you. And that's what one of the things that you need to work on on voir dire specifically, because a salesman is successful not because of what he sells, but because he sells himself first. In order to be a successful salesman, you just have to sell yourself first. And that's the opportunity that occurs on voir dire, where you're selling yourself, and you're selling yourself by entertaining them and educating them. I cannot stress that enough.
And educating and entertaining doesn't mean, you know, a variety show on TV. It means exposing the jury to the kernel of justice you're trying to achieve, or the kernel of injustice you're trying to prevent. It's the theme that you're going to present in the coming days after they've been deselected. What is the kernel that lies at the heart of this case? And you can entertain them, because that kernel is interesting if you present it in an interesting manner. That's why I don't think you are not hamstrung if you have a complicated case with a jury that nobody graduated high school. If the lawyer does her job and presents the case in an understandable story where you expose the kernel that lays at the heart, any jury will find the right answer. Hopefully that's the answer you're looking for.
If you could go back a second on this slide. One of the things that I see a lot of novice trial lawyers do is on voir dire, when they start to ask jurors to define things, you never do that, because you're going to set themselves up for embarrassing them when they don't know the answer and there's a pregnant pause. Whenever you want to bring up a legal term or some term that is not of average, what goes on in the average world, you just tell them what the legal concept is. And then you ask them to give you an opinion about it. And that promotes conversation, because whatever legal term you give them, and then you ask them, what do you think about that, Mr. Smith? And Mr. Smith says, well, I think this, and that. Then that begins the conversation, because then you turn to Miss Jones and you go, Miss Jones, you heard Mr. Smith's opinion regarding this. What do you think about that? Then Miss Jones says something which may be a little bit different than what Mr. Smith said. And then from there you go, Mr. Whatever, Mr. Troy, what do you think of what Mr. Smith and Mr. Jones said? And then you become the moderator of the conversation. And in that conversation, you're going to get to hear what the jury really thinks, what each juror thinks about these ideas and these concepts that you want that are going to be litigated at the trial. If you ask them yes or no questions, that gives you nothing but a yes or no. Being the moderator on a voir dire is what you should strive for.
Because
Conversation.
If you do exactly what Oliver's suggesting, you will see something that I call coalescence. The jury, when they can't get out and they are asked to stand in the jury box and raise their right hand and swear to well and truly try the case, coalescence is something that I'm still corny about. I'm still emotional about. They coalesce into something called a jury, and they try like hell to reach the right answer. So if you get them talking back and forth, you might be able to pick who has the ability to be the foreperson of this jury, who might listen to others in the jury. And to give a concrete example of the improper use of legal terms and the proper use of legal terms, say you're trying a construction case and the general contractor is being asked to indemnify the owner for defective work of a subcontractor. You might ask a jury. There is a concept called indemnity. Indemnity is such that the general contractor could be called upon to pay my client for the failings of a subcontractor, even though the general contractor didn't do anything wrong. How do you feel about that? And you will find some jurors say, well, that doesn't make sense to me. I don't like that. I don't think that's fair. Boom, peremptory challenge. A challenge for cause, because they can't follow the law. You got to flesh it out. Well, if the judge instructs you that that's the law, can you follow that instruction? Some jurors will say, no, I can't follow an instruction I don't think is fair. And you have set the groundwork for a cause challenge, as opposed to using a peremptory challenge.
Now, although I say that you have to entertain, but as in the last two notes, you have to know how important their job is. And I think one way that most jurors, it resonates in most jurors when you tell them, look, this is about the Constitution. The Constitution is just a piece of paper unless citizens participate. And the only other duty which you're required to physically appear in is a draft. So unless you're of draft age and we reinstate the draft, the only other thing that the government requires of you to do to show up someplace is for this. And the reason that they ask you to show up for this is because that's how the Constitution continues to be alive 200 plus years later. It's participation that is required and an important job of being a citizen of this country. And so you're entertaining, you're educating, but then boom, you lower the boom by letting them know, hey, this is really, really important. It's not a frivolous thing when you go back there and you have to hash this stuff out, because you want thoughtful jurors that take their job seriously.
Okay, before we move on to the next slide, panelists, we have 5 more slides. We're running a little late, so just keep that in mind, and we have to reserve some time for questions.
Okay.
Don't speed through it. I
okay.
just want you all to be aware.
Yeah, no. Obviously, whatever theory of prosecution or defense you have starts with voir dire. It does not start with opening. I mean, I think that speaks for itself. From the minute you open your mouth to the last thing that you say at trial, it should be promoting your theory of prosecution or defense, and it begins in voir dire. One of the things that I always like to do on jury selection is to let them know this is a job interview, and not everyone is suited for a job. Not everyone can be a plumber. You know, I always joke around. I always played basketball, but for some reason the NBA never hired me. You know, maybe for my lack of skills and my height and everything else. But so what you're trying to impart upon the juror, that especially a juror that you may not want and is reticent to be there, he'll grab onto that. And you tell them, look, there are other cases in this building that you may be suited for, but not everyone's suited for every single case. If there's negative issues in your case, you have to discuss them in voir dire. You cannot hide it. If you don't discuss them in voir dire and they show up during trial, they're going to look at you and say, what were you hiding from me? You're just another sleazy lawyer. Whatever bad issues you have, it's better to get them out front. Next.
And I think this is going to be our last slide. And this is a quote from actual voir dire, from an actual juror who claimed that he could serve on this case, claim, I'm not biased. I just feel sorry for your mother. And when the lawyer asked why, the juror said she has to live with the shame of knowing what her son does for a living. But no bias. She's completely open-minded. Unconscious bias is very real, and drawing biased people out. There are different wordings you can use, comparing this to a race, talking about it as a job interview, talking about them maybe being a better juror in a different case, talking about your own biases. I don't know, you love cats or something like that, and you wouldn't be able to be a fair juror in a case where somebody tortured a cat. Come up with your own example, talk about your own biases, make it easy for people, and try to stay away from the actual word bias, or unfair or close-minded or anything like that. And I think that concludes our presentation.
But if we have 30 more seconds, I don't mean to put the pressure on you, Oliver, but I did promise that you would explain backstriking for those that have not encountered it.
Right. Usually here in Florida, backstrikes, like I said, are absolutely is the law. So typically what happens after you go through voir dire, the judge then says, okay, 1 through 6, any strikes, jurors 1 through 6, any strikes. If you're smart, you don't say anything. The other side says, okay, we're going to strike juror number 3, whether, you know, they have cause or whether it's just a preemptory strikes. That's one less strikes that they have. And I always wait for the back strikes unless
and that puts juror 7 in the box.
Right. And then maybe you prefer juror 7. So, and again, okay, so now 1 through, you know, number 3 is gone, then we go to 7. And they say, any back strikes? Now it's your turn. You go, I mean, any strikes? You go, no strikes. And then it goes back and forth. So you hold them on like they're precious, because once you get the 6, and then they're gonna say, do you tender? And then that's when you start using your back strikes. No, judge, I'm going to use strike number 1 on juror number 1. So you don't show your cards. You want to see if the other side wants to show their cards first.
And some states don't allow that. So rule number 1, find out what the rules are in your court and what the
Right.
judge prefers.
Yes.
Okay, we have one last slide, which is experts.
Well, a lot of people, attorneys feel and clients feel that if only they got smart enough people on their jury, they'll win the case. And unfortunately, that is a very common psychological bias. People who agree with us, they're the smart ones. People who don't, they're the idiots. And we don't even understand where they're coming from.
Can I take a
So
different- Go ahead, I'm sorry.
Yeah. No, my position is you are the smart juror. You cannot expect as somebody on the jury to simplify things for the jury. It's your job to make your case accessible for all. And relying on one juror is dangerous because it's a one-man jury.
And by way of counterpoint, I am not equating a smart juror to a strong juror. I agree with Galina that a strong juror is dangerous because that person can hijack the rest of the jurors, can just strong arm them into ruling the way they vote. I'm talking about a smart juror who may have an easier time grasping the concepts that underlie the construction dispute. For me, it's like, I like trying, if I have a non-jury case, I like trying it in the complex business division here in South Florida because we have smart judges that try these cases and they understand it. And I can take shortcuts on explaining vocabulary. So I'm not saying that a strong juror is necessarily good, but smart jurors are.
All right, that concludes the presentation. Joe, do we have any questions? I'm going to stop sharing my screen so we can see everyone.
I don't see any. None in the chat room now. If anyone has one and can hang on a minute, feel free to post. While we're waiting, I'll ask you one, Galina. So you not only help pick juries and identify themes, but one of the things you do is you work with trial lawyers. You're largely talking to a group of construction lawyers here today. Do construction lawyers present any particular challenge to you when you're helping identify a trial theme?
I wouldn't say the construction lawyers present changes. It's the principals that they work with. The people who are general contractors and contractors, that is I've seen some amazing personalities. A lot of them tend to be very rude, politically incorrect. And I've seen lawyers begging for psychotherapy after they had to spend some time with them. So in that sense, I had to have quite a few conversations with lawyers trying to, get them boost their resilience because of the people they had to deal with.
Can I also point out that a jury consultant such as Galina should be retained way early in really large cases with lots at stake that I've been involved in. The jury consultants put together mock trials where we bring a jury in before trial and we present the case and what do they think? And that helps us fine tune the presentation that we'll make to the real jury. And shadow juries, if the case is large enough, a jury consultant will convene a shadow jury that sits in the jury in the courtroom during your day. And at the end of the day, you can get feedback from them, which may have more or less of a correlation as to what your actual jurors are thinking. But don't just hamstring yourself to thinking a jury consultant helps you with jury selection. There's way more value to a jury consultant.
Right.
That's
Well,
two plugs,
thank you.
Galina. That's two plugs, okay?
Thank you.
I'm an honest lawyer. I say what I think.
I just want to say that it does not have to be a big expensive mock trial, although sometimes in a big case, this is absolutely what you have to do. Sometimes it's consulting kind of a conversation, discussing the themes, figuring out the story without the research. But research is where we learn things and how we learn things. So, and sometimes it's not even a jury trial. Joe, as our other experience tells us, a federal judge or a state judge likes a good story just as much as the next person.
Mhm.
So
I mean,
in a way,
Our federal judge recently said, I just want to remind the trial attorneys that I am a jury of one and I enjoy to be entertained. So, yeah.
I mean, from my experience as an assistant public defender, we don't have the kind of funds to do that. But we have what's called staffing, where you present the case to a bunch of colleagues, and in the process of presenting the case, and they listen, then you get their feedback, and then you fine tune, or they pick out issues that maybe you failed to pick out. And in the process of that staffing and the conversation that take place with the colleagues, you're refining, you're polishing, and your presentation becomes that much better. So I encourage all of you, if you're an office of a handful of people, and maybe you walk into that office, or you schedule a staffing with all your other lawyers and talk about the case, and you'll see that things that you missed, there's going to be additions that you didn't pick up on, and your presentation will become that much better, even if you cannot afford someone as Galina.
actually, I worked for public defender's office, so sometimes they manage to get the state to give them the money.
So if there are no additional questions, it's Stu's birthday today, so I know that Galina and Oliver are going to sing happy birthday to him. And
Yes.
I'm-
Oh, yay.
Happy birthday. You don't want me to
Thank
sing.
Happy birthday, Stuart.
Thank you, everybody.
All right, contact information, Stu, Galina, and Oliver. You want to give them your email addresses, should there be any additional questions?
Sure. My email is olivermorales1961@gmail.com.
And I'm G. Davidoff at davidoffconsulting.com. You can find me if you just Google my name, you'll find me.
Right, and I'm S. Sobel at siegfriedrivera.com.
All right.
All right.
Thank you,
Thank you very
everyone.
much to our panel, and thanks for everyone for attending.
Thank you for the
Thank
opportunity.
you.
Thanks, everybody.
Bye-bye.